All right, we're gonna get our meeting started. I apologize for the late start. We just had a executive session, so we're gonna start off with the Pledge of Allegiance. Pledge allegiance to the flag, of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, we'll get started with a roll call. Here.
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 Here. Zoning solicitor and zoning officer are also present.
All right. All right, our first application here is application Z 2024-25. Kevin Murphy of 366 Radford Court in Glen Mills. This is pertaining to the subject property at 301 First Avenue, Newtown Square. The applicant is seeking variance relief from section 307 First Avenue, seeking variance relief from section 172-29A to allow for a sober living facility. Applicant also requests relief from any other section of the zoning ordinance that may be realized during the zoning hearing process. Who do we have on behalf of this record application? Mr. Sikora, yep. So let's have yep.
Do whatever order you want. This might take a while. There's a lot of neighbors, I think, want to talk. I don't know if you have other stuff on your agenda that's quick. Because we could be here a while. Doesn't matter to me.
No, I know. We kind of had that conversation prior to the meeting about whether or not we should get started on this application first, based on the amount of people that are here, and this is the order of it. What do you think?
Well, it's up to the board, obviously. The other two applicants are present. For them, one of the other applicants represented by council, he won't be here.
Then let's just get started in order then, yeah. All right, so let's have everybody take a seat that is here. Do we have the other microphones for them for the tables instead of the hand?
We got one here.
Okay.
We don't need one for each of us. Let's give me and you can share. Let's here, take two of these to place out there. Rich, can we give you this one that is better handheld or not?
There's no order.
We're good. One for them, one for us. We're
First one
good.
there.
Yeah. Yeah, we're all good. As long as they have one each table, we're good. So.
Just leave these on.
So. All right, so Rich, you're here for the township. Are you here to represent the applicant?
Robert DeLuca,
Have a
yes.
seat over here, make yourself at home.
He's not on behalf of the
Oh,
applicant.
I'm sorry. I thought he was.
On behalf of the Reds.
Bring it up.
On behalf of the.
Who do we have here? Who's the applicant?
Come up here.
Come on up.
And it might be worthwhile before we just start with questions, if we can kind of frame why we're here, and I'm happy to
that's
tell you why
fine.
the township's here.
And Mr. Murphy?
Yes.
Okay, so let's get Mr. Murphy sworn in.
I do.
And let's make sure the file is in order as well. We'll get that.
It's in order. I don't know that we can look at the exhibits. However, by the fact that mailings were sent to all property owners within 200 of the property boundary, property was posted. The township posted. But the notice was also placed in the local paper. Chairman, based on the recommendation of our zoning officer, they asked that we have to document.
One, that the list of residents within 200 feet of subject property were notified of tonight's meeting be
noted as Township Exhibit number 2. Proofs of publication in the Delaware County Daily Times on 2 consecutive weeks be marked as Exhibit number 3. And the picture of the posting the property for this evening's meeting be marked as Township Exhibit number 4 and made part of the record.
They are admitted. And we are going to get, so anybody that here is as a party protestant, just single file, step up to the podium. Should be a microphone there. I just need you to state your name, your address. And the people that are party protestants, I need to know that, you received a letter, you're a party protestant, which gives you the ability to appeal any decisions that are made here tonight. So if you received a letter because you live within a certain distance of the house and are impacted by this, please step up to the podium, name, address, and then stay there. We'll get you sworn in.
Excuse me, is that applied to other neighbors that are exceed that 200?
You're actually not able to
But they
appeal.
can participate by virtue of public
You can make a public
participation.
comment.
But if they're not directly affected by the application,
How is
Just
that
to
measured,
the-
by the way? How do they
Did you get a
measure-
letter?
Yes, how do they measure?
Andy,
where?
what's the distance that
From
they
the
do?
property boundary.
From
There's a
property boundary.
200-foot radius taken off of the computer-generated plot plan.
I understand the corners of the property or
Yeah.
He didn't receive a letter.
I'm just saying.
Well, I
This
have
is,
sight of the
It's your
mailings.
rule, or your rule, I'm just wondering why you didn't get a letter.
I can't answer that question at the moment. I can tell you that we mailed it within, using our computer-generated system.
I'm
I'm just
curious.
answering your question.
Of it.
I mailed it,
I
we
think,
mailed it
I
to
think
every.
it would be better.
listen, if guys, before we start the meeting this way, because we're not going to do this, all I ask is that if you received a letter, just step up to the podium, state your name, your address. We have a lot of people here, so let's get through that part of it.
Patrick McDevitt, 304 First Avenue. Is that all you need?
And then stay there because we're gonna have to swear everybody in. So step back, let the next person up.
Terry Werner, 314 First Avenue. Werner, Werner. ER.
Donald Warner, 314 First Avenue.
Henry DeVoe, 318 First Avenue. DEVOE, yes, sir.
Nick Cox, COX, Nick Cox, 305. Sorry, Nicholas Cox. Yep, 305.
Thank you, First Avenue.
Megan Cordes, 305 Second Avenue. CORDES. D is in David, E is in Edward, S is in Sam.
Gary Bernhardt, 305 Second Avenue. BERNHARD.
Milana Ennis, 218 Media Line Road. WILANA, capital ENNIS. 218 Media Line Road. Okay,
Kenneth Orr, ORR, 315 First Avenue.
Donna D'Agostino, 103 First Avenue, also known as 103 Berman Street. DAGOSTINO.
Donald D'Agostino, 103 First Avenue and Bourbon Street.
Carol McDevitt, 304 First Avenue. Georgiana Kane, 302 Media Line Road. KANE.
Andrew Kane, 304 and 302 Median Line Road.
And Sam, do we want to get anybody that thinks they should have received a letter or at least state their name? We can look into it later.
well, we have those, you did not receive a letter?
Correct.
Well, we'll note that.
Okay. Do you want to just get their name on the record?
She did. She's
Oh, all
on
right,
the
sorry.
record.
All right, then let's get all right, let's get everyone sworn in.
Yeah.
All right. So, and I know you had,
Yeah, one more.
oh,
Oh, hi. I'm on Fourth Avenue. Is it okay if I go too?
Get a letter?
No, but it's still, I'm in the avenue, so it still affects me.
Well, why don't you put your name and address
Okay,
on the record?
thank you. Kimberly Ricciardi, 401 Fourth Ave. Ricciardi, thank you. Ricciardi. Thank you. Yes, I do.
All right. And I know, Mr. Score, you had some
So,
points you wanted to make before we got started.
Right, so I'm here on behalf of the township and some of the zoning board members, I believe, were on the board back in 2019, 2020, when we had a sober house proceeding in a different neighborhood back in the Heights. And similar to that, the township is not here to oppose the use of a property as a sober living facility. Township recognizes that there are certain rights under the Americans with Disabilities Act and the Fair Housing Amendments Act that allows reasonable accommodations, actually requires reasonable accommodations to allow certain individuals, if they qualify as persons with disabilities, to live together as a family unit, even if they don't technically comply with the township rule of three, no more than three unrelated persons is what constitutes a family. It's how the house is used. And then it's so the nature of the issue that the township here is, number one, to make sure, A, the folks that are using the house actually are folks with disabilities, because that's the first thing, does the law even apply to them? And then two, if so, what is a reasonable accommodation? The township is in no way to know what a reasonable accommodation is until we hear the testimony. We're going to listen to the evidence about the program, may need more evidence. I suspect that at the end of this evening, township's going to request a continuance to bring in further evidence, much like we did before. We have an expert that we used. Don't know if we need that expert until after we hear the testimony, and then hopefully maybe all the people can get together and work something out in the meantime, but you never know. So I just want to clarify that we recognize the rights to be able to use this property. We're not here in any way to discriminate against the applicant's proposed use. We just want to make sure, A, they comply, they qualify, B, that the request for accommodation is reasonable. Okay, that's right.
Understood. All right. So, Mr. Murphy, the floor is all yours.
So I'd like to thank everybody for coming out tonight for this hearing. I'm not exactly 100% sure. I didn't get a ton of direction on how to make an opening statement for something like this. For me, I'm more than willing and happy to answer anybody's questions and field comments, for their concerns. I can speak a little bit about the program that's offered at the house and the effect that it's had on me personally. This is something that I hold pretty personal to my heart here, and excuse me if I get a little upset talking about it. But programs like this that are in neighborhoods like this are very rare. And for someone who is a person in recovery and struggled with substance abuse for a long time, the opportunity that I had, because I lived at this house for 2.5 years, from 2017 to 2019. The house began as a sober living facility in 2014. So it's been operating at this location for over a decade at this point. But the opportunity that I was given, it was coming out of an inpatient rehab facility. I could have gone here, or I could have gone to Chester, or I could have gone to Levittown. Levittown I had never heard of. There's a ton of sober living facilities up there. Chester, I'm a Delaware County native, right? I know there's good neighborhoods in Chester, but for me, it didn't feel like a place that I would want to be, considering a lot of my addiction was circled and encompassed in and around Chester. So to have the opportunity to come somewhere in Newtown Square gave me a sense of comfort. I was going to be in a safe place. I was going to be in a neighborhood that was familiar to me and surrounded by families and houses that I was familiar with growing up. So that provided a big level of comfort for me, and it allowed me to get my life back together and get back on, a path that, that I felt like I needed to get back to. Having said all that, like I mentioned, operating for over 10 years, right? So started in 2014, I came to the house in 2017. When I was moving out in 2019, I wanted to stay involved in the house. I became partners with the person who was operating the house at the time, which was something that I was super proud of. And, it was becoming a story that I was proud to talk about, that I was struggling for so long and then was given an opportunity in this township to start to recover and begin this journey. From that time on, about a year and a half later, I took it over myself. I took it over, and I joke about this sometimes on my own. April 1st of 2020. So 2 weeks after the pandemic started, I became the owner of said sober living facility. And that's Murphy's Law. That's a joke I make. If anybody here is open to jokes, Murphy's Law. Yeah, right. Anything that can go wrong will go wrong. That's what they say. Anyway, when I took it over by myself, I wanted to continue the program there. The person that was running it with me did not have the time to do it. He was moving on to bigger and better things in his life. Me, other than the recovery house and the new career that I was beginning in the substance abuse field, I didn't have too much going on. So I was happy to take it over and provide the opportunity, like the same opportunity that was given to me for countless gentlemen that have, come into this program and not known what to do next. I'd be hard pressed to find people in Delaware County, especially, that haven't been touched one way or another by, this, by the opiate epidemic, by just the substance abuse crisis that's going on in this country. And to be able to provide an opportunity for people like that, for people like me, keep that going was a real honor and a pleasure. So with that said, in operation for 10 years, under my watch alone for the last 4.5 years, no major issues, pretty minor stuff with neighbors at times, things that you would see in any typical neighborhood, but there have been 0 arrests or citations issued at the house. Like I mentioned, no major altercations with neighbors. We keep the property very well maintained. We keep it pretty seasonal. We have, we give out candy during Halloween. We have Christmas lights up. I always, when I'm talking to people before they come to live at the house, the way I describe the house is, if you drove by it, you'd never know what goes on inside there. And I feel pretty confident that that's how the house appears on the block. Most of our residents are locally employed. They support local businesses. They pay local taxes. I myself, first job in recovery was right here in Newtown Square. Historically, like myself, many of the residents are Delaware County natives. They grew up in Delaware County. They went to school in Delaware County. Their families are in Delaware County. So families love hearing that there's an opportunity for their son in Newtown Square. And I can provide testament to that if you'd like. I can't do it tonight. I wasn't sure what this hearing exactly was going to entail, but I would be happy to provide testimony with parents whose sons have turned their lives around because of the magic that happens at this house.
Do you understand why you're here tonight? Do you know why you had to come in and the relief you're
I'm a little
actually
familiar with this,
of what you're looking for? And I'm not trying to cut off your opening statement. I just want to make sure in terms of getting there, for what you're looking for. So you obviously have a large amount of people that are here as potential party protestants or as party protestants that want to make sure you understand why you're here and what.
Are you
you're
talking,
going
are
through.
you referring to the section 172.29A?
The relief that you're looking for, yeah.
I'm familiar with it. I'm not well versed on it, but I'm familiar with it, yes.
And really just kind of taking us through, you know, what the hardship is, what the relief is you're looking for. You know, I look at something like this based on our previous application that Mr. Square referenced, and one of the issues that came up there was the amount of people living in the facility.
Mhm.
You know, so for you in the property that you're at, what's the maximum amount of people that have been there at any given time?
Sure.
Maximum, what's
Yeah,
the most you've had
maximum is
there?
15.
15 people there.
Right.
And listen, here's the other thing too. So we are gonna ask questions. We don't need, you'll have an opportunity to ask questions. You have an attorney here. We'll get there. I have questions. We've been through this before. Just bear with me. So 15 does not seem like people agree with that, but
Yeah, and to their reaction to it, it sounds like they had no idea that there was that many people living in the house. It is a,
so can we not do that? Can we not do that? We have a court reporter who has to, he has to take notes. We do not need everybody jumping in from the crowd. If you're sitting in one of the tables up here, or if you're at the podium, that's how we'll kind of handle this. I just don't want this to get out of hand. That's all I ask. It's not a hard thing. All right?
sure. And the house, there's 5 bedrooms in the house
Okay. So
So
even with
it's not-
that you had 3 people in each bedroom potentially.
on average.
Okay. And for this, in terms of relief, for what you're looking for is what is the acceptable amount of people that can live in a facility like that?
I suppose.
Again,
I'm asking it for it to go beyond 3.
beyond,
3. My understanding of this section is that no more than 3 people without the same last name can dwell, reside and cook under the same roof. Is that about right?
The township's zoning ordinance
Yeah.
defines a single family as no more than 3 unrelated people living together as a single family unit.
okay,
Obviously, these folks that come to a sober living
Right.
facility aren't related, but they're entitled to a reasonable accommodation to be able to live together as a family. The issue becomes what's reasonable, right? So,
Yeah.
you know, we'll ask questions, but, you know, things such as 5 bedrooms, we had it listed as a 2-bedroom house on the county record, right? So we got to get testimony as to, is it 5 bedrooms, 5 legal bedrooms?
do you want us, or are you done with your opening statement? Do you want us to turn it over to Mr. Score to
Yeah,
ask?
I'm okay with that.
Yeah,
I don't
I mean,
wanna-
so.
Yeah, I just want to provide a little bit of a
No,
background.
that's,
So, and I don't want to stop you from putting any evidence in, but I mean, what you said in your opening statement is essentially what you came here to say tonight, right? So. I'm
yeah,
not-
I didn't mean to cut you off.
Oh, no, it's-
Comfortable with where you got to, or?
So, Rich, if
Yeah.
if you're gonna ask questions as essentially cross-examination, we don't have any real evidence from him per se.
no Right.
testimony.
I know you want to ask the questions, and I know you'll bring out that evidence.
Right,
But technically, it would be your witness as on cross,
I'd say you get sworn and
which you don't really
testifies,
want.
and then we'll cross-examine.
But you know what I'm saying?
no, I know, that's kind of what
I would
So-
request that he be sworn and testify, and then we can cross-examine from that point.
what.
Was I not already
Do you
sworn?
understand the burden you have here? With regard to making out a case to support a deviance or a variance from the ordinance as it provides for 3 unrelated? You want more than that.
Correct.
And there's a basis you have to show or carry the burden that there's a reasonable basis for the board to consider a variance.
Can you give me an example of what that would sound like?
Well, I think.
Beyond what
I-
is covered in the Americans with Disabilities Act and the federal.
Well,
Fair
I
Housing Act?
understand that, but we have to evaluate what a reasonable accommodation to that is. So I think we need to know the size of the house, the size of the bedrooms, how many kitchens, do you have a basement? What's the basement used for? How many cars parked in the driveway? We need to make a judgment call on whether 15 people are a reasonable accommodation for the size of this property and the nature of the neighborhood.
Understood.
So,
Yeah,
and the
be happy
burden is
to
on
answer
you
all
to
those
provide that. And after you provide that information, then the attorneys are gonna question you on that. And then we'll have a fair understanding of what's going on at the place,
Can you explain to me why the burden is on me?
because you're the applicant. You're asking for the relief.
Understood.
You haven't consulted with a lawyer, I take it.
I have not. No, I came here in good faith tonight. I didn't hire a lawyer.
Okay, well, we appreciate that, and I understand that, and I can tell, you feel the need to request a continuance to have an attorney?
I'm
give you
here
some
to,
help?
I'm here to answer any questions that you guys might have. I'm here to.
I think what they're trying to do here is make sure that you understand that if you do answer these questions and a decision is made tonight without you having representation, that is that a risk you're willing to take? They're basically saying, do you want to have a continuance and maybe get an attorney so you can come in and address all these things? Because they're going to ask a lot of questions about the house, the space. There's going to be a lot that you don't want to basically be unprepared.
And I don't want to win. Yeah.
Oh, excuse me, the other thing you might want to.
Microphone on.
Is that you have all the statistical information that we're gonna need. The bedroom size, the size of the house.
Okay.
Basement, what you use the basement for, how many parking spaces you can have.
Yeah,
What are the kind of questions you're gonna get asked?
Understood. And I would have loved to have come here tonight with the answers to all those questions. I asked somebody upstairs what I needed and they couldn't provide me the answer. So, you know, this is my wheelhouse coming in and testifying and, you know, providing these details. I can speak to it because I know the house up and down. But if you need exact square footage per room, you know, I can't provide those exact numbers to you tonight, no.
I don't even know how hard pressed you'll be for that. I really just think what you're being told here is you probably should consult with an attorney. This isn't to waste everyone else's time for coming here. You just want to make sure everybody gets a fair chance here, but you do seem, you know, unprepared essentially. And again, we're happy to move forward with, if you're comfortable with that, but I think what everybody's telling you here, that just, yeah, we want that on the record, that you were given this information and, you know, you can do what you want with that. If you want us to continue moving forward, and we'll go based off the testimony that's given tonight and the answers you give to the questions and take it from there. It's your call.
There's things like, who owns the house? Do you have a lease for the house? I mean, these are things that we need to know to evaluate your case.
Yeah.
We
well, so-
understand what
and
goes
that's-
on in the
that's
house.
thing,
in
Sam.
terms
I
of-
don't know what I don't know, so until.
Well,
those
that's why
questions-
an
so
attorney
until
that
those
has done
questions are
this-
asked,
But an attorney that's done this before would tell you that this is how it's going to go, and these are the things you should be prepared for.
Okay.
It's nothing against you. It's just, you know, I'd be the same way if I was sitting in your seat and I showed up here, but I think what they're saying is you should, again, do what you want. They're just trying to provide some actual kind guidance here and saying this is what you should do.
Sure, appreciate it. Yeah, let's do it.
Otherwise, we'll make a decision tonight based on everything that's here and, you know, it is what it is, but your call.
I also don't want to take up more time, you know, now I'm in a position where,
This is how it goes.
yeah, because I don't want to take up more of the neighbor's time. But if this is what you're recommending, I'm not against it. I'm not against the continuance and hiring a lawyer.
Might make it quicker.
Yeah.
Certainly more efficient.
All right.
Thanks.
Well,
Well, let's-
does anyone want to make a motion
I move to accept his continuance until next month.
what's the date on that if we're gonna?
So the one thing that just an idea, I don't know if there's an objection to it. A lot of folks came out, I think they want to talk. I know it would be out of order. But they're not cross-examining the witness, but if they just want to get
Make a
what they want to
statement.
say on the
Yeah.
record, maybe the people don't have to come back if they don't want to come back.
And the applicant will hear some of the,
Some of the concerns, and you can get an idea of what you got to be prepared to
I
address.
mean, we can do that, but I may bring him back to address what he testifies to at that
no,
point.
there's no prejudice to that.
I got it. I don't have a problem with putting some of them on this evening, to address their concerns and what they've seen, because there hasn't been a variance for this house and it's been in existence and there've been complaints to the township, although it hasn't been legally running.
So how do we want to handle this if we are going to have people step up to make comment? I know how that can go, that it's going to be coming back and forth. Are we looking for people to just make comments so that they're on the record for their stance on this? Because
Why don't we just wait till?
that's why I feel like if we start to go down that rabbit hole, it's not going to be good. So, all right. I apologize, for everybody that is here for this, that it's going to have to be continued. I know it's a big undertaking to have to be here. I am sorry, but I think this is actually for everybody's best interest. So we're gonna make a motion to, well, do we want to put it on there now to get do we want to do it to November 21st, right? Is that what it would be? So I'll make a motion to continue application Z 2024-25 to the November 21st hearing date. Is there a second?
Second.
All those in favor?
Aye.
Motion carries. I'll see you in a month.
Yes. We'll give you a card. Okay. When you're paying counsel, you can ask them, give me a call, and we'll go over the procedure. All right? Yeah. I get
So if we could if we could have everybody step out into the hallway so we can get our next application. I'm sorry. You're welcome to stay too, but anybody that's, hey, Rich.
The microphone's here, because we need a microphone back.
Sam, thanks for calling me back.
Bob, Frankie.
Yeah. That he does. So our next application is
In his old building.
That was just the first one that wrapped up, right? That was the first one that wrapped up? Yeah. I'm on the third one.
Don't worry. Yeah, I'm not here.
But you know what? You got this exposure.
Yeah, I got this is good food.
Right.
Put your neighbor down.
All right, we good to move forward to the next application, application Z 2024-26. Kate Stauffer of 309 Earles Lane. The applicant is seeking variance relief from section 172-29B subsection 6 to allow for encroachment into the required side yard setbacks. The applicant also requests relief from any other section of the zoning ordinance that may be realized during a zoning hearing process. Subject premise is located in the R1 district. Do we have Mrs. Stauffer here? You're the, Kate Stauffer is not here? That,
We're the contractor that's
the fence, is that,
the deck.
or the, sorry, the deck? Yeah,
Authorized to speak, the,
Yes,
do we have something in writing?
I don't have anything. Never required.
Unavailable?
why don't you make that call and we're gonna put you last, then we'll jump to the next case for now.
So she's the applicant. If there's a letter authorizing them to speak on.
All right, we are gonna move to application Z 2024-27. Karen Raquelle Amours, 103 Tanglewood. The applicant is seeking variance relief from section 172-104A to allow for a fence in the front yard. The applicant also requests relief from any other section of zoning ordinance that may be realized during the zoning hearing process. Subject premise is located in the R2 zoning district. Andy, is there, actually, you want to get sworn in?
Yeah, so, Jonathan Long on behalf of Miss Amours. So what we were thinking about doing tonight, with the board's approval, Miss Amours is from France, so English is not her first language. So my thought that she did it before when she had to be here in front of the board once before a few years ago. Her attorney made an offer of proof, and then she was put under oath and sworn in and essentially swore to what he said, what he presented, and that's what we, if the board's okay with it, we'd like to do tonight.
I'll defer to our solicitor. Is that acceptable, I guess?
We had a conversation about this and if there are specific questions that the board or any protest want to direct to the applicant.
Thank you. Okay.
Question. Testimony. Or make records.
So how do we address questions to the applicant?
I mean, she can sit up here with me.
Oh,
Um,
I'm sure we should stay.
What's that? No, I know, I got that. I was getting there. You know, I can give the basics of the case and then and she can adopt that. And then if you guys have, you know, finer points that you have questions about, either myself and or her can answer them. You know, she'll be under oath, so she can always say, you know, sometimes I'm able to express it a little better than her maybe. But, you know, she's here and she can answer your questions as needed.
And is the file in order, Andy?
File is in order, I don't know. But in any event, mailings were mailed to all property owners within 200 feet of the boundary. We also physically posted the property with the evening notice. And the notice was also advertised in local paper on 2 separate occasions. I think.
Chairman, based on the representation. Plain officer, I ask that the evidence accompanying that at the time of application be marked as Township Exhibit number 1. That the list of 200 of the 200 of the residents within 200 feet of the subject property be noted as Exhibit Township number 2. And the proofs of publication in the Delaware County Daily Times in 2 consecutive weeks. Noting tonight's hearing be marked as Township Exhibit number 3. Finally, the posting of the property Uh, of, notice of tonight's meeting, be marked as Township Exhibit number 4.
All right, they are admitted. And guess we don't have anybody here for public. That wasn't in French.
Yeah, I was gonna say, obviously she understands.
Does speak English, and it's just.
It's okay, so, but no party contestants or public comment, so, all right.
All right, thank you. As I stated, I represent Miss Amours, she's the owner of 103 Tanglewood, which is right down the road. We're hearing an appeal of the township's notice of violation and or variance from, as you stated, section 172, 104A, regarding basically a fence or a structure in the front yard of the property. I'm gonna have sort of a twofold argument. One is basically what I would term essentially an estoppel argument. As I'll go through, Ms. Amours in the prior council talked to the township about what she was going to do with these planters that are in her front yard, and believed going forward that it was okay to do it. And the other one is a general variance argument, which is just a hardship. She did spend a lot of money and resources to put this up, believing that it was okay to do so. She owns a historic farmhouse surrounded by newer builds. If you look at Exhibit A3, those are photos of the old house. In 2021, she did go for a zoning approval for a fence, which is up closer to the house, enclosing a part of her yard. She did receive approval for that from this board. That decision is marked as A6. After that hearing in 2021, she and her counsel had a conversation with township staff. I believe it was Mr. Rezick and Zach Arts, I think is his last name. Afterwards, they took away from that conversation that what she was going to do with these planters, which are the basically big planters that she's put out in her yard with a post in them, and then they have cross rails between them. They believed she took away from that she was allowed to do that. And so therefore she went ahead and expended money and put these things up in her yard. You can see photos of them at A4. She did spend a considerable amount of money to do so. She spent approximately $6,500 in doing that. They are movable. They're not fixed to the ground. They have plants in the bottom of the planter, and as well as solar lights. They've remained in place for a number of years until she got the notice of violation back in August. As far as we know, there were no complaints about it in our conversation with the township staff early on in this. It was our understanding that basically it was a matter of they drove by and saw it and realized that it was in violation. So therefore that's why they issued the notice, that it was not a neighbor complaint or anything of that nature. My client believes that they add aesthetic to the neighborhood. She works very hard to make sure that they're very beautiful and they're very nice. Yeah, I'm getting it. So, as I mentioned before, there are solar lights in them. Those are pictures at A7 showing them at night. There are no street lights on Tanglewood, so they do provide some street light along the street to allow neighbors to be able to walk dogs, that kind of thing, provide some light at nighttime. So we do believe that they are a net benefit to the neighborhood. We do understand from, speaking with Mr. Rezick, that they are, I guess, within the right of way of the street. Obviously, she would prefer to keep them where they are. However, if she really has to, they can be moved out of the right of way further back into the yard if necessary. So. Yeah, so, yes, I forget what the exact amount is, but maybe it's 14 feet or something like that. We would work with the township, obviously, to make sure it's properly done to their liking.
Is it not permanent right now? It's just sitting in the planters? Like,
Yeah, they're not a
like
fix.
those posts could just slide back?
Yes.
Okay.
And in fact,
I do. I just didn't know if it was through the planter and.
no, it's sitting in the planter. And I think that's where some of the confusion came from, is she believed that they took away from the conversation with the township that the fact that they were not a fixed and a permanent structure, therefore it was allowed. However, reading and looking at the definition is very broad.
and really just, it's basically any kind of object, something of that nature. So that's basically what we're asking for today. Well, actually, do you want to put it on your own? Hold on. Raquel, hold on.
Lots of English.
No,
Raquel.
I speak a good English, but in the term of all those paperwork, it's very
Yeah.
difficult.
Yeah, in a legal setting, she struggles to understand
Yeah.
things, that kind of thing.
Yeah.
So Raquel, he's gonna swear you in. So can you raise your right hand? He swears the testimony.
Yes.
Right. So Ms. Amours, you were present for my presentation, correct?
Right.
All right. Is everything I said true and accurate to the best of your understanding?
Right.
Okay, sorry. Now, because you're under oath now, would you accept my presentation as if it were your own testimony? We'll leave out the pause.
Brings your credibility into play.
Is there anything else that you would like to let the board know about about the fence or the planters?
Should I speak?
Yes,
Okay.
this is your chance.
I think it added a lot of beauty to the property, to the street. Like I say, the street is very dark in the night. People jog, walk their dogs, and I think it adds. Even if you see the picture between my neighbor, this is a little bit newer. It separates our property together. He asked me, hey, Raquel, I want to pay half and half with you. And I said, no, this is my, don't worry, I will do it. And there's no, so to me, everybody was so happy for like 3-4 years. And I'm just a little bit surprised why suddenly it's a problem, but I understand I'm too close from the street. And I read in the paper that I could go 14 feet or 12 feet. I'm ready to do that. I'm ready to pay more my worker, my landscaper to do that.
So you're willing to work with the township
Yeah,
to make sure it's to their liking?
I prefer not to, but I'm okay to do it.
Okay.
No, I have, as you see on the picture there, my neighbor on, if you're facing the street from the property, my neighbor on the left, I made the same fence for him to separate our properties together. He loved it. Yeah.
I believe what she was saying is he had offered to split the cost. She said, no, I'm gonna keep it on my side and I'm gonna pay the whole cost.
I didn't want to be obligated. Yeah.
You know how far it is off the curb now?
It's at the front is 3.5 feet, and the other on the cul-de-sac is 4 feet. And the property is 175 feet from the street.
Meaning your house.
Yes,
Okay.
yeah. I remember that from the last time I was here with the other fence.
Andy, do you have any concerns with this from a safety standpoint with, I get,
Well, the only concern that would be the impact of the right of way. And also the clear sight triangle leaving the driveway, make sure anyone leaving, coming and going from the driveway the fence itself isn't impacting that vision down the roadway one way or the other. Now, I do understand this is at the ball of the cul-de-sac as well.
yeah,
So maybe that's not so big of a concern, but the right of way impact is. And I do want to address one comment by the attorney. We did have a meeting prior to this hearing, and we did discuss previous conversations. I want to say on the record that I have no recollection of being part of that conversation. I don't know if Mr. Axe, who's the property maintenance inspector, had a prior conversation with the property owner. The problem is, if he did, I'm not aware of that. He's not here to testify. And, normally what I try to do is do things through email, especially when it's giving someone an approval. And in a situation like this, knowing the prior, hearing involved the fence and limitations of our fence ordinance, it was abundantly clear from that hearing that, the front yard fencing was an issue. It would have been addressed at that time. So I think I'm on record as being clear to the need for a variance of section 104 right from the get-go.
Okay,
And
so,
that's, and yeah, that was, yeah, obviously, we don't have anything in writing. And that's why I was phrasing it more of, my client took from that conversation that this was allowed. I'm not necessarily saying that they said, oh, it's absolutely allowed kind of thing.
so my concern with the whole right of way, right, with that, with this not being a fixed install, is that less of a concern? Obviously, if something were to pop up, to know that these planters could just be dragged out of the way
Yeah,
if need be.
we did have some conversation about the definition of a fence, and I think it meets the definition of a fence. It's nice, the fact that it's not permanently affixed into the ground where you have to physically, lift the poles out of the ground and replace the post, in there. So it makes it a little bit easier.
And I only ask that if we were to, if this is something that were to be approved, is that a stipulation that we could put on there that they could never be permanently fixed there, that if they were to just remain in the planter, so it doesn't become a permanently fixed fence in the right of way?
Well, and also that maybe a condition could be that the homeowner is responsible in the event the township or utility company wants to
Yeah.
access that right away, that the responsibility falls on the property owner
Yeah.
from this point forward,
Yeah, okay.
and all future property.
Yep.
My landscaping company have a very large tractor, and when they come and do my landscaping, they remove few posts where they need to go, and then
Yeah.
replant it, so there's access.
Well, I think more just concerned about the ones that are in the front now that are in the planters, that they do not become a permanently fixed install. But I guess at the same time too, if this is something that were to be approved, that it is going to fall on you if for any reason that section needs to be accessed for any sort of digging, plumbing, or anything like that, that burden falls on you. Just asking if that's something, but I think my initial point was, that we approve this and all of a sudden it doesn't become great, let's dig up and make these fence posts permanent.
No, and if you wanted to make a condition that they could never be
Yeah,
permanently affixed, that's fine. There was no intention to do that in the
Okay.
first place. They're posts in pots, so.
and Andy, from in addition to that, if this were to be approved, anything you would want to see change from a safety, knowing that they're in the cul-de-sac like that?
I don't really think that there's a major safety issue.
Yeah, good enough. I always like to check with you for that, so, okay. Any questions from the board on this or any concerns? Sam?
No, I just want to make sure if it's favorable, that I have the conditions. So obviously, one of the conditions that if the board should so choose to approve would be that the entire fence be moved out of the right of way, at least 14 feet. That the sightline clearance might require some additional space at the driveway. We're also indicated that if there are any utility or township needs, that the homeowner would be required at their cost to move the fence. Fence should never be permanently affixed. And any requirements necessary for the fencing would be a requirement of the applicant.
I have a
Also put
question.
in there.
So as I am now already like 300 feet away from the street, in certain area, and I'm 4 feet in other area, the cul-de-sac. For you to give me 14 feet back, does it include?
No,
We're not looking for
We're not gonna do that.
Just let,
Oh.
I think what they're looking at doing is
Keep it as is.
leaving it as is, but making it that if something happens and it has.
Now I'm leaning,
It's on you.
now I'm leaning towards this, now I'm leaning towards 14 feet back since you said something.
Put all your head.
The other stipulation that we were just saying to maybe put in there too is obviously because of the line of sight that it remain a split rail fence and that it not be permanently, affixed to the.
That's up to the
Cannot
board.
be-
You know,
Just
so
with the-
we're gonna leave, you're suggesting that the fencing as it exists today
Correct.
stay subject to removal if
Location,
we
well,
need it?
cannot ever be
Okay,
permanently.
so we're allowing the right of way. I missed.
Yeah, there was no concern because of being in the
Okay.
cul-de-sac like that, and the right of way was fine.
Okay,
And since it's so dark, that's the hardship.
No, you're okay. We'll 16 feet now.
You know me,
I do.
I cannot resist.
Anything else that we're, okay.
I move we grant the variance, from 172-104A with the stipulations that, it remain a split rail fence and not be permanently, fixed to the ground and movable in case, it needs to be done and remain in its current location within the right of way.
And all the additional terms that for Houselander
We'll
read
write.
off there, so.
right, thank you.
Is there a second?
Second.
All right, all those in favor? Aye.
Aye.
All right, motion carried. Good luck with your fence. See you on the next one.
Appreciate it.
So Mike, were you the second? Oh,
Thank you very much. Thank you, sorry. I
Quite
couldn't
welcome.
resist.
No problem.
Thank you. Thank you, sir.
Thank you all.
Who was the second on the, Mike?
They actually both said at the same time.
Good luck.
Okay. It was all.
Yeah. That great.
All right, guys, how'd you make out?
We call them email, she's.
More than one?
When our, who sets up the, variances at work, she's called, I spoke with, Heather, I don't know her.
Yeah, Heather Hastings.
And to ask, what do we need, what's required, like, ask all the questions, and they, about us, because we applied for the variance in their behalf. and-
But the application is in the property owner's name.
Yeah. No, I understand.
So I think what Heather gave you is that Heather's the administrative assistant, so she accepts your application. The application was complete because it had the property owner's information, it had the deed, it had the application. The expectation is that the applicant represent themselves here this evening. If the applicant chooses to give you the ability to do so, we wouldn't know that, but you have to get standing from that property owner in order to be legal. Did I explain that, Rick?
Yeah, absolutely.
No, I understand. I've gone through variances with other townships that they don't require that. That's why it was.
Well, we don't know that you're authorized to do that.
I don't know. I
We
understand
just need the
wholeheartedly.
link.
I just apologize if this is where.
No, that's not a problem. She's not available tonight, is that what happened?
And answer you down, let's make voicemail and I emailed her.
Yeah, so essentially, we'll just continue it till next month.
And,
You want to be in front of or behind the next group?
Yeah, that's what I think was scary.
if we get a signed letter from her, is that?
Yes, if she would sign as the applicant homeowner and authorizes you to represent her interest at this hearing, she signs it, we'll accept that.
Awesome. Thank you so much. Sorry for.
We need to-
No
problem.
My name's Sean.
We need to go on the record.
Continued on the record.
Yeah,
Yeah, we didn't motion.
Langford, LANGFORD.
let's get
Continue it
the,
for 20, 24, 26, right?
yes. That'll be continued to November
November.
21st as well. Is there a second?
Second.
All those in favor?
Aye.
Aye.
Looks like I'm-
I think we can make that happen.
Appreciate it. Thank you, guys.
Yeah, thanks, Ed.
All right.
People told me that you guys gave names. Or do I have to give my name or can I just come next? Or, okay, and then I had a question. I'm just, from my knowledge, if they're not zoned to be there, how, like, from my explanation, how can they be there now? I don't know how.
Well, I guess the reason from the township's perspective, know that.
Okay,
So we never had an application that would have generated any investigation.
okay,
Until more recently, when we received the
There was some.
complaint, we looked into it, and then we, reported it.
okay.
So, and in a situation like this, I mean, Sam may be able to explain it better than I, but a group home has certain protections under Fair Housing Act.
Yeah,
So it's not that it's not necessarily not approved.
okay.
The use itself.
Oh, gotcha.
Yeah.
Okay, but they're trying to get like zone.
What they're technically asking for is an accommodation under the Fair Housing.
Okay,
So it really.
so
it's
they're
being
technically,
used as a
there's
single
zone
family.
for it.
It's trying to use it as a single family home, but beyond the scope of our code. Under.
So then like, so if they're trying to use it as a single family, are they able to stay there?
Well, it's an application.
Oh, okay,
Yeah, because
Okay.
they may, like,
because it's pending, but
Yeah.
okay,
so what happens is they're gonna make an application and accommodation is a federal
yeah,
law. Okay, so that, they have to show that they fall a disability. So, courts have found that, which is.
Meeting adjourned.
Disability.